crimes against chastity. The first among these is the crime of adultery. Adultery is committed when a married woman shall have sexual intercourse with a man who is not her husband, and by a man having carnal knowledge of her, knowing her to be married, even if the said marriage be thereafter declared void. So here the offender would be the married woman, and she has sexual intercourse with a man who is not the husband. And likewise it is committed by the said man who shall have carnal knowledge of her, knowing her to be married. What if the man didn't know that she is a married woman? Even if the man didn't know that she is a married woman, the said man shall also be prosecuted in court for the crime of adultery together with the said wife. Adultery is a private crime. It can only be the complaint can only be filed by the private complainant, that is the husband. And the husband has to file a case against both the wife as well as the said other man. The husband cannot file a case against only one of them. It must be against both of them as provided for under Article 344. Therefore, it is only a defense on the part of the man that he did not know that this woman is a married woman. And if he would be able to prove that he lacks knowledge that the woman is a married woman, then it can happen that only the woman will be liable for adultery, and the said man will be acquitted of such crime of adultery. Adultery is a kind of formal crime. There are no attempted and frustrated adultery. Adultery is punished only in the consummated stage. And adultery is consummated upon the carnal union between the said married woman and another man, not her husband. What if the husband, upon entering the house, found his wife in actual sexual intercourse with another woman? Is the said or the husband file a case of adultery? Will the case prosper? The case will not prosper. The law expressly provides the married woman having sexual intercourse with another man. Therefore, it must be a man in order for adultery to lie against the said married woman. If adultery is the crime of the married woman, how about the man, the husband? The husband would be liable for concubinage in the following instances: by keeping a mistress in the conjugal dwelling, by having sexual intercourse under scandalous circumstances with a woman who is not his wife, and lastly, by cohabiting with a woman who is not his wife in any other place. So there are three ways of committing concubinage. Again, in order for concubinage to prosper, the information or the charge for concubinage to prosper, the said wife, who is the offended party, must file the case against both her husband and the concubine. In case the concubine didn't know that this man is a married man, just like in case of adultery, it is just a matter of defense on the part of the concubine that she is not aware that this man is a married man. If she would be able to prove that she lacks knowledge that the man is a married man, then there are instances wherein she would be acquitted of the said crime charge. There are two kinds of acts of lasciviousness under Article 336, acts of lasciviousness under circumstances of rape, and under Article 339, acts of lasciviousness under circumstances of seduction. In case of Article 336, acts of lasciviousness under circumstances of rape, here, the offended party can be any person, and the acts of lasciviousness was attended by any of the circumstances present in rape, by using force, threat, or intimidation, when the offended party is deprived of reason or otherwise unconscious, by means of fraudulent machination or grave abuse of authority, or when the offended party is under 12 years of age or is demented. Under Article 339, acts of lasciviousness under circumstances of seduction, the offended party is always and always a woman, because in seduction, the victim is a woman, And the said woman must be over 12 and under 18 years of age. And the said acts of lasciviousness must be committed under circumstances of abuse of authority, abuse of confidence, abuse of relationship, or by means of deceit, because it is under circumstances of seduction. Acts of lasciviousness refers to any act which is prompted by lust or lewd design, which has not been initiated by the victim herself. The accused, so X, called on the helper of their house. The helper of the house was a minor. The helper of the house was only 16 years old. And the helper of the house, was only 11 years old. And the said owner of the house called on the said helper to enter the room. Of course, she's being called by the helper, and so the said girl entered the room. And the moment she entered the room, the said master of the house told her to undress. She was shivering, she was afraid, however, she has to follow. And so, she undressed herself, and then thereafter, the said master of the house started touching her breast as well as her genitalia. However, the door opened, the wife came in, and the said wife stopped everything that the said man had been doing. What crime has been committed by the said man? That is a core problem. What crime has been committed by the said master of the house? The master of the house is liable. Is the master of the house liable of acts of lasciviousness under the RPC? Or is the master of the house liable of lascivious conduct under RA 7610? Or is the said master of the house liable of attempted rape? That is a 2015 bar question. Last bar, the question was, if the slightest penile penetration already consummates rape, when is rape attempted? So here, in the problem, is the act committed by the said master attempted rape? When is there attempted rape? And when is there only acts of lasciviousness? First, is the master liable of attempted rape? The master is not liable of attempted rape. As held by the Supreme Court in the case of People versus Cruz, in order to amount to attempted rape, there must be evidence that the erected penis is capable of penetration. And, as held by the Supreme Court in the case of People versus Venezuela, in case of attempted rape, it is necessary that there is already the intent to insert the penis in the genitalia of the said woman. There is already the intent to penetrate. But there was no slightest penetration. That is attempted rape. In the problem, the master only touched the breast and the genitalia. There is no intent to penetrate. Therefore, it is not attempted rape. So is it acts of lasciviousness under the RPC, or is it lascivious conduct under RA 7610? It is acts of lasciviousness under the RPC, under Article 336. There was intimidation on the part of the said master of the house, and by reason of the said intimidation, the said acts of lasciviousness were done. However, look at the age of the girl. The girl was only 11 years old. Therefore, the crime committed is lascivious conduct under RA 7610. Because under Section 5, letter B of RA 7610, if the lascivious conduct is committed on a child under 12 years of age, the penalty shall be reclusion temporal in its medium period. So the crime to be charged would be lascivious conduct in relation to RA 7610. We go to seduction. We have first, under Article 337, qualified seduction. There are two kinds of qualified seduction. Qualified seduction of a virgin, and the other one is qualified seduction of a sister. Qualified seduction of a virgin is committed when the following elements are present. First, the offended party is a virgin over 12 and under 18 years of age. The second, the offender is a person of public authority, a priest, a house servant, a domestic, a teacher, a guardian, or any person entrusted with the custody and education of the woman seduced. Third, the said man has carnal knowledge of the said girl. And lastly, the carnal knowledge was brought about by abuse of authority, abuse of confidence, or abuse of relationship. So, in this case, it is necessary that when the said offender had carnal knowledge of the said girl, a virgin over 12 and under 18 years of age, it is necessary that there was on the part of the accused abuse of authority, abuse of confidence, or abuse of relationship. The other kind of qualified seduction is qualified seduction of a sister. Here, the offender is a brother, the offended party is a sister. The brother had carnal knowledge of the sister. The carnal knowledge was brought about by abuse of relationship. In case of qualified seduction of a sister, the age is immaterial. Even if the sister is already 18 or above, an adult, there can still be qualified seduction of a sister. Likewise, virginity is immaterial. Even if the sister is already a married woman, there is still qualified seduction of a sister. In case of qualified seduction of a virgin, virginity here does not refer to physical virginity. For as long as the girl is single and is living a chaste life, the law presumes she is a virgin. X, 16 years old, was schooling in this public institution. In one subject, the teacher of X was Mr. Y. One time, after school, when a room inside the school was opened, the janitor found X having sexual intercourse with Mr. Z, one of the teachers in the school. This was discovered, and the mother filed a case of qualified seduction against Mr. Z. Mr. Z, however, had the following arguments and insisted he is not liable. First, according to him, based on their sexual intercourse, he discovered X is no longer a virgin. Second, according to him, he is not a teacher being referred to. He is not a teacher being referred to in qualified seduction of a virgin because he does not handle any subject wherein his student is X. Therefore, he is not the teacher being referred to in this case. Are his arguments correct? Insofar as the virginity is concerned, it suffices that this girl is a minor, 16 years old, and she is living a chaste life. The law presumes she is a virgin. As to the argument of the accused that he is not a teacher in the subject, therefore he is not a teacher being referred to by law. The teacher being referred to by law does not necessarily mean the teacher of the girl, the victim in any particular subject. It suffices that his position is that of a teacher and he exercises authority over the said girl. He being a teacher in the said public institution, he exercises authority and moral influence over the said girl. Therefore, the said sexual intercourse was done with abuse of authority and abuse of confidence. Hence, he should be held criminally liable as charged. The other kind of seduction is simple seduction. Simple seduction is the seduction of a woman who is single or a widow of good reputation over 12 and under 18 years of age committed by means of deceit. In case of simple seduction, the offended party is a woman who is single or a widow of good reputation over 12 and under 18 years of age. And the offender had carnal knowledge of her. And the said carnal knowledge was brought about by means of deceit. Whether it is qualified seduction or simple seduction, there is always the element of carnal knowledge. Without carnal knowledge, there is no seduction, whether qualified or simple seduction. In case of simple seduction, the man's carnal knowledge of the said woman, of the said minor, was brought about by deceit. And this deceit usually comes in the form of a promise to marry, a promise of marriage. The man wanted to have carnal knowledge of the girl, but the girl would not surrender her virginity to the man without marriage. The man promised marriage. The girl surrendered her virginity, but no marriage occurred thereafter. There is simple seduction. X and Y are boyfriend and girlfriend. The girl was 15 years old, and the girl was in a faraway province. The girl although she is already 15, she had stopped schooling after grade 1. The man, however, is working here in Manila. The man is already 25 years old. They met through a common friend. Since then, they have this relationship, and the man would often go to the said province to visit the girl. One time on their date, the man tried to have carnal knowledge of the girl, but the girl refused, saying that her parents told her that she would only surrender her virginity after marriage. And so without marriage, there can be no carnal knowledge. So because of that, the man, going back to Manila, devised ways and means on how he would be able to have his girl. And so she talked to his friends, a male friend and 2 female friends, and he told the male friend if it is possible for him to act as the mayor and the female friends to act as witnesses. He will represent himself as the mayor, and he will solemnize their marriage. And he will make the said girl believe that they are married, that they are already married. And so after they have already conspired on everything that they will do, the said man brought the girl in Manila, brought to the house of the friend, and introduced the friend as the mayor of the place. And told the girl, based on our law, the mayor has the power to solemnize her marriage. And so the girl believed, and so because of that, the marriage was celebrated with the 2 witnesses, the female friend. Believing that she is now married to her boyfriend, on their honeymoon, she gave her virginity to the said man. But it was a fraudulent marriage. What crime has been committed by the man and the friends? They are liable for 2 crimes. First, we have simple seduction. There is simple seduction because this man, with the help of the friends, was able to have carnal knowledge of this girl, 15 years old, who is a woman living a chaste life, single, living a chaste life, by means of deceit. And what is the deceit? The deceit that they had already been married. Any other crime, they're also liable for usurpation of official function under Article 177. The said friend pretended to be the mayor of the place and performed acts pertaining to a mayor of person in authority. The said usurpation is necessary means in order to consummate the act of simple seduction. Therefore, the crime committed is simple seduction through usurpation of official function. Under Article 342, the law punishes forcible abduction. Forcible abduction is committed when a man abducted, carried away, take away a woman against her will and with lewd design. So the victim is always a woman, and the man carried her away, took her away, against the will of the woman. At the outset, there is on the part of the man lewd design. There is on the part of the man lust, in so far as the said woman is concerned. In case of forcible abduction, having carnal knowledge is not an element. So if in the course of forcible abduction, the man would have carnal knowledge of the said woman, and the said carnal knowledge was against the will of the said woman, a crime of rape is committed. The accused passed by the house of X, and seeing X on the staircase of the house, waiting for the arrival of the parents, he forcibly opened the gate, and then thereafter he carried away and took away X, boarded X in the tricycle, and brought X to his house. At the outset, there was on the part of the man lewd design. The girl was asking for help, but no one helped the girl. And so, the said man was able to carry away the said woman. Brought the woman to his house, and there held the woman. That night, the said man had carnal knowledge of the girl, of the said woman, by using violence and intimidation. On the second night, the man again had carnal knowledge of the said woman by using violence and intimidation. On the third night, again, the man repeated the act of carnal knowledge by employing violence on the said woman, until the woman was rescued. What crime or crimes had been committed by the said man? The man actually committed 4 crimes. We have forcible abduction. He carried away the woman from her house against her will and with lewd design. He also committed the act of rape on the first night, the second act of rape on the second night, and the third act of rape on the third night. Therefore, all in all, we have 4 crimes. But how many charges would you file in court? You have to file 3 charges. One is rape through forcible abduction, and then the other one is 1 count of rape, and the other one is another count of rape. So all in all, 3 information must be filed in court. The first one is rape through forcible abduction. The forcible abduction was a necessary means in order to commit the first act of rape. But for the second and the third act of rape, the said forcible abduction is no longer a necessary means. Therefore, you complex the first act of rape with the forcible abduction. So here, the accused would be liable of forcible abduction with rape or rape through forcible abduction and 2 other counts of rape, separate and distinct from each other. What if in the same problem, when the man carried away the woman and brought the woman inside his house, that night, he tried to have carnal knowledge of the said woman. He undressed the woman by force, undressed himself, and tried to penetrate the said woman. However, the woman put up a very strong struggle. He was able to grab a piece of wood, and he hit the man, and finally she was able to escape. And so, she informed the authorities. 2 cases were filed against the man. One is forcible abduction, and the other one is attempted rape. Are the charges correct? The charges are wrong. The crime is only 1 crime, and that is forcible abduction. To give rise to a complex crime of forcible abduction with rape, it is necessary that rape is consummated. If rape is merely attempted, it is absorbed in the crime of forcible abduction, because the attempt to rape the victim is a manifestation of the lewd design element of forcible abduction. So if rape is not consummated but merely attempted, it is absorbed. Hence, the crime committed is only one, and that is forcible abduction. X was on his way to work. Driving his van, he passed by the supermarket. Passing by the supermarket, he saw the wife of his rival in the business. He was so mad at the rival of the business, he wanted to threaten him by detaining the wife. And so, he got out of the van and forcibly abducted the wife, and thereafter he brought the wife inside his house. He tied the hands of the wife and detained the wife. That night, X had carnal knowledge of the said wife of his rival in the business. On the second night, again he had carnal knowledge of the said wife. On the third night, again he had carnal knowledge of the said wife. Later, the wife was rescued. What crime or crimes had been committed by the man X? X would be liable for the special complex crime of kidnapping and serious illegal detention with rape. Even if the said woman was raped 3 times, the number of the acts of rape are all absorbed in the single indivisible offense of kidnapping and serious illegal detention with rape. It is kidnapping and serious illegal detention with rape because here, at the outset, there was no lewd design. The act of taking was done intending to get a revenge at the rival in the business, to threaten the said rival in the business, and to detain the said wife. Therefore, it is kidnapping and serious illegal detention with rape, and all the other acts of rape are deemed absorbed in the single and divisible offense. What if in the same problem, when X abducted the said woman, the wife of the rival in his business, brought the woman inside his house, and the said man, X, tried to have carnal knowledge of the said woman. When he tried to have carnal knowledge of the said woman, he forcibly undressed the woman, undressed himself. And he tried to penetrate the said woman, but the said woman put up a fight. The woman was able to hold a lead pipe and hit the man, and she was able to escape. She informed the authorities what crime or crimes may be filed against X. 2 cases may be filed against X. One is kidnapping and serious illegal detention, and the other one is attempted rape. Kidnapping and serious illegal detention because he abducted and detained the said woman. The intention is to get a revenge at the enemy, at the rival in the business, and to detain the wife. And he attempted to have carnal knowledge of the said woman, therefore it is attempted rape. It is not a special complex crime because there's no special complex crime if rape is not consummated. The special complex crime requires the rape must be consummated. So here, the attempt to rape the victim in the kidnapping constitutes a separate and distinct charge. So the following are the distinctions between kidnapping and serious illegal detention with rape versus forcible abduction with rape. First, kidnapping and serious illegal detention with rape is a special complex crime. It is the law that combines the crime. Whereas, in case of forcible abduction with rape, it is a complex crime under Article 48, the forcible abduction being a necessary means in order to commit the act of rape. Second, in case of kidnapping and serious illegal detention, at the outset the intent is to detain. Whereas, in case of forcible abduction with rape, at the outset there is lewd design on the part of the offender. Third distinction, in case of kidnapping and serious illegal detention with rape, if there are multiple acts of rape committed, all these multiple acts of rape are absorbed in the special complex crime of kidnapping and serious illegal detention with rape. Whereas, in case of forcible abduction with rape, if there are multiple acts of rape committed, you only complex one act of rape with forcible abduction, and the other acts will constitute separate and distinct charges. And lastly, to amount to kidnapping and serious illegal detention with rape, the rape must be consummated. If rape is merely attempted, it will constitute a separate and distinct charge. And insofar as forcible abduction is concerned, to amount to forcible abduction with rape, the rape must be consummated. If rape is merely attempted, it is absorbed in the crime of forcible abduction, it being a manifestation of the lewd design element in forcible abduction. So those are the distinctions. We have kidnapping and serious illegal detention with rape versus forcible abduction with rape. The girl was only 15 years old. She was inside her bedroom. Her brother-in-law, that is the husband of her elder sister, entered the room. and despite her pleas and cries, the said brother-in-law had carnal knowledge of this 15-year-old girl against the will of the girl. 2 weeks thereafter, the girl in her uniform was on her way to school. She was already nearing the gate when here comes a tricycle. On board the tricycle was the brother-in-law. The brother-in-law alighted from the tricycle and thereafter went to the girl and forcibly grabbed the girl and brought the girl, boarded the girl inside the said tricycle. From the school, the said brother-in-law brought the girl to the house of his parents, and in a room, he had carnal knowledge of the said girl, the sister-in-law. Later, the girl was allowed to live, and the man was arrested, the brother-in-law. The brother-in-law was charged of 2 crimes. One is qualified rape. The rape that occurred inside the bedroom in the house of the girl. And the other one is forcible abduction with rape. The rape that occurred after the girl was abducted in school and brought in the house of the parents of the man. These were the charges. If you were the judge, would you convict the accused as charged? In this case, the Supreme Court did not convict the accused as charged. Although the accused was convicted by the RTC and the CA as charged, when the case reached the Supreme Court said, the man is liable for 2 counts of qualified rape. After the first act of rape, it is evident it is qualified rape because of the twin qualifying circumstances of minority and relationship. The girl was only 15 years old, and the man, brother-in-law, was a relative by affinity. Therefore, there is the twin qualifying circumstances, hence it is qualified rape under Article 266 B. What about the second act when the girl was abducted in the school, and then thereafter, after the girl was abducted in school, she was brought to the house of the parents, and there she was raped. Isn't it forcible abduction with rape? Supreme Court said no. Supreme Court said, it is not forcible abduction with rape because here, the obvious intent of the brother-in-law is to rape the sister-in-law. Since the obvious intent of the brother-in-law is to rape the sister-in-law, the crime committed is qualified rape. The forcible abduction is merely incidental. So in this case, the Supreme Court convicted the accused of 2 counts of qualified rape. The other kind of abduction is the so-called consented abduction under Article 343. Consented abduction is the abduction of a virgin over 12 and under 18 years of age, committed with her consent and with lewd design. So in case of consented abduction, the victim again is a virgin over 12 and under 18 years of age, a minor. And the man abducted her, carried her away, but this time, it is with her consent. At the outset, there was lewd design on the part of the man. Just like in case of forcible abduction, in case of consented abduction, carnal knowledge is not an element. Therefore, if in the course of consented abduction, the man who abducted the girl would have carnal knowledge of the girl against the will of the said girl, an act of rape is committed. And since the act of rape was committed by reason of consented abduction, again, it will give rise to a complex crime. That is, rape through consented abduction. X and Y are boyfriend and girlfriend. The girl was 16 years old. The man was 22 years old. They love each other, but the parents of the girl did not like the man. The man enticed the girl that they better elope to show and prove their love to the parents of the girl. After several times of inducing the girl, finally the girl agreed. And so the man took away the girl with her consent. At the outset, there was lewd design on the part of the man. The man brought the girl in the house of his parents. Nighttime comes. The man tried to have carnal knowledge of his girlfriend. The girlfriend refused. The girlfriend put up a struggle, but the man was too strong for her. The man employed violence on her and was able to have a successful carnal knowledge of his girlfriend. What crime or crimes had been committed by the man? In reality, the man committed two crimes. One is consented abduction and the other one is rape. But since the consented abduction is a necessary means to commit the crime of rape, we have the complex crime under Article 48 of rape through consented abduction. Under Article 344, that is the provision of the law which provides that the crimes of adultery, concubinage, seduction, abduction, and acts of lasciviousness are considered as private crimes. Therefore, these are crimes which can be prosecuted only upon a complaint coming from the private offended party. It is also this provision of the law which provides that the subsequent valid marriage between the offender and the offended party in crimes of rape, in crimes of seduction, abduction, and acts of lasciviousness would extinguish the criminal liability of the offender and would remit the penalty already imposed by the court. And Article 344 provides, this applies not only to the principal, but also to the conspirator, the accomplice, and the accessory. Under Article 345, the law provides for the civil liability which may be imposed on the offender in rape, seduction, and abduction. We have to indemnify the victim woman, to acknowledge the offspring, and to give support to the offspring. We go to Title 12.